Blord posted this. Nigerians in their quest to find out more discovered this. So in case you don't know, Blord has trademarked the name Rattle. His intention is that before Very Dark Man and his followers will use that name Rattle for any commercial purposes, they will have to sought permission from Blord. Now, trademark is the registration of any name, symbol, or logo for commercial purposes. It is governed by the Trademarks Act of Nigeria. And for you to do this, you have to register on the Trademarks Registry in Nigeria. When you register a trademark, it gives you exclusive rights to use that particular logo, symbol, or name for commercial purposes within the class with which you've registered the trademark. There are 5 things you need to know legally as regards to registration of trademark and how it affects the Blord and the Very Dark Man saga. And before I get into this video, if you are not following me by now, you are missing out on a lot of information already. Number 1, the provisions of the Trademarks Act allows you to register your brand name, your logo, or your symbol, and then trademark it. This trademark helps you to stop other purported users from using that name, logo, or symbol within the same commercial class for business purposes. More so to this, it is to desist from misleading the public. Take for instance now, 2 companies, only 1 brand name. It could confuse the public. So now, the right to using a brand name that is trademarked is the right absolute. When a person registers their brand name, their logo, or their symbol, does it automatically stop every other person from using that name? And whenever any other person goes ahead to use that name without the permission of the person who trademarks that name, what happens? That takes us to number 2. Number 2, the Nigerian Trademarks Act follows the NICE system of classification, dividing goods and services into 45 sections. Section 1 to 34 covers for goods, while section 35 to 45 covers for services. The legal implication of this is that an identical word can exist in multiple classes, so far it does not mislead the public. I'll give you some examples. Do you know that there are 2 Apple companies trading under the same Apple brand? The first one produces phones and chargers and AirPods. The phones you and I use, Apple phones. There's another Apple company that's into music and entertainment. More to that, there is a Dove company that produces soaps, shampoos, etc., etc. There's another Dove company that produces confectionaries, chocolates, bread, etc., etc. So there are actually instances where 2 companies, distinct companies, can exist with the same brand name or trademark logo or even symbol. So far you guys do not exist under the same class, you are allowed. So far as it's not misleading the public, you are allowed to do your businesses with the same brand name. The instant case of Very Dark Man and Blord using Rattle now, the registration of Rattle by Blord is registered under FinTech and Online Commercial Services, which is most likely under Section 42 thereabout. While Very Dark Man has registered his under Community and Education Services. Does that make any sense? Now, the both parties, that's Very Dark Man and Blord, can both use the identical word Rattle for different purposes. They are allowed to trademark it independently. So far, it does not mislead the public. And in this instant case, it most likely cannot mislead the public because what Very Dark Man does is outrightly different from what Blord does. So Blord going ahead to register or to trademark the word Rattle does not stop Very Dark Man from going ahead to use and trademark Rattle as well. So far, he is not registering or trademarking it under the same class, being FinTech and Online Banking Services that Blord had already trademarked. Number 3, under Section 13 of the same Act, there are some exceptions to which you can use the same identical trademark or logo for different purposes. This in most instances is, however, subject to a review by the Registrar of the Trademarks Commission or most times by the court. What does this mean? This means that a registration of a trademark or logo or brand or whatever you have does not grant you exclusive, distinct right to use that trademark alone. The particular aim of this law is such that the public should not be misled or be confused. So Blord coming out viciously, as can be deduced from his posts, make an attempt at limiting him and his users from the usage of the word Rattle would fail ab initio, because the aim of the laws on trademarks are not to grant trademarkers exclusive rights to use of name. The aim of that law, as at the time the law was being passed, is to stop brands from misleading the public as regards to use of name and identity. Fourthly, there is another principle called the principle of prior use. It is provided for under Section 7 of the Trademarks Act. So now, did you know that if you've been using a name for a long, it's what we call conventional usage or perpetual usage or usage over time. You've been using this name for as long as possible. Let's say a brand name like Baron. You've been using Baron for a very long time, but you did not trademark it. Somebody comes now and trademarks the name Baron. Does it stop you from using that name Baron? If you can go to court or to the trademark registry and prove that you've been using this name One. Two, it is widely recognized that a lot of persons know you for that name or know your brand for that name. Three, you've been using it for commercial purposes. The principle of prior use can still avail you, can still come to your aid to help you to trademark that name, even if both of you exist in the same class. You can go to court and prove that you've been using this name for the longest time being. You can bring your evidence to show that you've been trading with this name for commercial purposes, and there's a wide acknowledgement. It's a fact of common knowledge that this name has been attributed to you or to your brand. You can use that as a defense against the person who just registered this name. Applying this principle to the instant case, let's take for instance, Very Dark Man was also into fintech and maybe online banking services and had failed to trademark the name Ratel. But Very Dark Man is able to prove that he's been using the name Ratel since 2022, and the public knows him for that name, and he cannot be identified with that name, and he's been using it for commercial purposes. The defense of prior use will still avail him against Blord, even though Blord has gone ahead to trademark the name. Last but not the least, at number 5, what happens when somebody actually uses a trademark name, symbol, or logo without prior permission of the actual owner? Now, such an instance is referred to in law as an infringement of a trademark right. There are 4 elements that must be present to prove infringement. First, that there's actual use of the name, brand, logo, etc. that is trademarked. Second, that it is being used for commercial purposes. 3, that it is being used without the authority of the person who has trademarked it. And 4, that it is most likely to confuse or mislead the public. If any one of these 4 elements is missing, you cannot establish the thought of trademark infringement. And if you establish the thought of trademark infringement, what are the possible remedies? You can sue for an injunction. You can sue to ask the court to stop the person who is purportedly or is already using your trademark in a violating manner, to stop using it. You can request for damages, which is the most famous one. Yes, you can go to court and claim damages. Damages include payment for that breach and also how much damage the person has caused him. Like, let's say somebody uses your trademark now in a manner which has affected your own business. The cost to assess the damages you yourself have suffered, and you'll be paid accordingly. Third, there's what we call delivery or seizure in usage. Whatever that person is using that brand to do, maybe let's say 2 different companies. One is producing phones like Apple, and his brand is trademarked. Another person is using it to do newspaper or magazine publications. For seizure and delivery of, you go to court to ask that all the properties or all the machinery that person is using to produce those magazines should be seized. This is in order to stop the person from further production of whatever goods or services they are producing, which is affecting your brand. So if Blord can establish these 4 mentioned elements, you can also proceed to court against Very Dark Man, claim for damages, ask for seizure, and ask the court to stop Very Dark Man from purportedly or furthermore using his brand name, the Ratel. But Blord should be ready to prove the 4 of these elements existing at the same time. Alright, that will be all for today. Thank you guys for watching, and until my next video, remain blessed.